Welcome to my channel. Today we will discuss about polity and governance current affairs. 1. Economically weaker sections, EWS, Quota. The economically weaker sections, EWS, Quota is a reservation quota introduced by the Indian government in 2019, aimed at providing reservation to economically weaker sections of the society who were not covered under any existing reservation scheme. Here are some important points related to the EWS quota. 1. Eligibility criteria. Individuals with an annual family income of less than 8 lakh rupees and possessing less than 5 acres of agricultural land are eligible for the EWS quota. 2. Reservation percentage. The EWS quota provides for a 10% reservation in jobs and educational institutions for individuals who meet the eligibility criteria. 3. Implementation. The EWS quota has been implemented in all central government jobs, as well as in higher education institutions such as the IITs, IIMs, and central universities. 3. However, the implementation in state government jobs and institutions is left to the discretion of the respective state governments. 4. Impact on existing reservation schemes. The EWS quota has been implemented without affecting the existing reservation schemes for scheduled castes, scheduled tribes, and other backward classes. 4. Hence, the overall reservation percentage has been increased to 60% in central educational institutions and government jobs. 5. Constitutional amendment. The EWS quota was introduced through a 103rd constitutional amendment, which required amending Article 15 and Article 16 of the Indian Constitution. 6. Criticisms. The EWS quota has been criticized for being implemented without any data on the number of eligible individuals and the impact it would have on the existing reservation schemes. 6. Additionally, there are concerns that the EWS quota may further increase the competition for limited job and educational opportunities, and may not effectively address the issue of economic inequality. Overall, the EWS quota is a significant policy measure aimed at providing reservation benefits to economically weaker sections of the society. However, its effectiveness in addressing the issue of economic inequality and its impact on existing reservation schemes remains a matter of debate. Subcategorization of other backward classes, OBC. The Union Cabinet has granted the 14th extension to the Justice Rohini Commission, which was formed in 2017 under Article 340 to investigate issues related to the subcategorization of other backward classes, OBCs. The Commission has been given time until July 31, 2023, to submit its report. The National Commission for Backward Classes, NCBC, had earlier proposed subcategorization of OBCs into 3 groups, namely, extremely backward classes facing social, educational and economic backwardness even within the OBCs, consisting of Aboriginal tribes, nomadic and semi-nomadic tribes who have been carrying on with their traditional occupations. More backward classes consisting of vocational groups carrying on with their traditional occupations. Backward classes comprising of those comparatively more forward. According to NCBC, 11 states, UTs have already subcategorized OBCs for reservations in state government-owned institutions. Reservation for OBCs in local bodies. The reservation for other backward classes, OBCs, in local bodies in India varies from state to state. However, the 73rd and 74th constitutional amendments provide for a reservation of seats for scheduled castes, scheduled tribes, and women in local bodies such as panchayats and municipalities. Some states in India have also introduced reservations for OBCs in local bodies. For example, in Tamil Nadu, the state government has provided for a 30% reservation for OBCs in local bodies. In Karnataka, the state government has introduced a 27% reservation for OBCs in local bodies. The reservation for OBCs in local bodies is aimed at ensuring adequate representation of marginalized communities in the decision-making process at the grassroots level. This helps in empowering these communities and ensuring their participation in the democratic process. However, there have been debates over the efficacy of such reservations, with some arguing that they may lead to the dominance of certain communities in the local body structures. 3. Uniform Civil Code, UCC. Recently a private member bill titled UCC in India Bill, 2020 was introduced in Rajya Sabha. The UCC, Uniform Civil Code, refers to a single set of civil laws applicable to all citizens of India in their personal matters such as marriage, divorce, custody, adoption and inheritance. Provisions for UCC come under Article 44 of the Indian Constitution, which is a non-justiciable directive principle of state policy. Personal laws in India are currently governed by different religious communities and have been codified over the years through various pieces of legislation. There are some secular laws as well, but Goa is the only state in India with a UCC, which is implemented through the Portuguese Civil Code, 1867. What is Private Member Bill? In India, a private member bill is a bill introduced by a member of parliament, MP, who is not a member of the government, i.e., not a minister. Private member bills are introduced on Fridays, which are private member days, during a session of parliament. These bills are meant to draw attention to specific issues and propose legislation that the MP believes is important. Private member bills have a lower chance of passing because they do not have the backing of the government, but they can still be influential in shaping public discourse and raising awareness about important issues. In India, personal laws are governed by various religious laws that apply to individuals based on their religion, such as Hindu, Muslim, Christian, Parsi, and Sikh laws. These laws govern issues such as marriage, divorce, inheritance, and succession. The Constitution of India provides for the implementation of a Uniform Civil Code, UCC, that would replace personal laws with a common set of laws applicable to all citizens of India. However, the implementation of UCC has been a topic of debate and controversy due to concerns related to religious and cultural sensitivities. Article 44 of the Indian Constitution directs the state to secure for its citizens a UCC, but this provision has not been implemented so far. The Supreme Court of India has also observed that the implementation of UCC is essential to promote gender equality and eliminate discrimination based on religious affiliations. However, several religious communities have opposed the implementation of UCC, arguing that it would undermine their personal laws and cultural practices. As a result, personal laws continue to be applied in India, and their validity is protected by the Constitution. 4. Hate speech. NCRB reported about 500% rise in cases under hate speech law in 7 years. Hate speech has not been explicitly defined in any law in India, but it is generally understood to refer to speech that incites hatred against a particular group of people. In India, hate speech is addressed under specific sections of the Indian Penal Code, such as 153A and 295A. Hate speech can take various forms of expression, including images, memes, symbols, gestures, and objects, and it can be disseminated both offline and online. In India, hate speech is governed by various laws and provisions that aim to prevent and punish individuals who promote hatred and incite violence against a particular community or group. Some of the important laws and provisions related to hate speech in India are: Indian Penal Code, IPC, Section 153A of the IPC criminalizes promoting enmity between different groups on the basis of religion, race, place of birth, residence, language, or any other ground. The punishment for such an offense can be imprisonment for up to 3 years or a fine, or both. Representation of the People Act. The Act prohibits candidates and political parties from promoting hatred and enmity between different groups during election campaigns. Information Technology, Intermediary Guidelines and Digital Media Ethics Code, Rules, 2021. The rules prescribe guidelines for social media intermediaries and digital news organizations to regulate hate speech on their platforms. Protection of Civil Rights Act, 1955. The Act provides for the punishment of individuals who discriminate against any person or group on the basis of religion, race, caste, or sex. Constitution of India, Article 19, 2, of the Constitution allows the state to impose reasonable restrictions on freedom of speech and expression to prevent the promotion of hatred or incitement to violence. The Indian judiciary has also played an important role in regulating hate speech. The Supreme Court of India has held that hate speech can be restricted if it poses a clear and present danger to public order, and has also emphasized the importance of maintaining a balance between free speech and protecting vulnerable communities from hate speech. 5. Sedition. The Supreme Court of India has put the 152-year-old Sedition law, which is defined as an offense committed when any person attempts to bring into hatred or contempt or excites disaffection towards the government established by law in India by words or otherwise, in abeyance until the Union government reconsiders the provision. Sedition is a non-bailable, non-compoundable offense that bars the accused from government jobs, requires them to produce themselves in court at all times, and prohibits them from using their passport. In 2018, the Law Commission of India recommended the repeal of Section 124A of the Indian Penal Code, IPC, which defines sedition. In India, the sedition law is primarily governed by Section 124A of the Indian Penal Code, IPC, which was introduced by the British in 1870 to quell dissent against their rule. The law defines sedition as any speech, writing, or other form of expression that brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Over the years, the sedition law has been used by successive governments to suppress dissent and curtail freedom of expression. Critics argue that the law is unconstitutional and violates the fundamental right to freedom of speech and expression enshrined in the Indian Constitution. Judicial pronouncement in context of sedition law. One of the most important judicial pronouncements in the context of the sedition law in India is the Kedarnath Singh v. State of Bihar case, 1962. In this case, the Supreme Court of India upheld the constitutionality of the sedition law but also laid down important guidelines to prevent its abuse. The court held that the law can be used to penalize only those acts which involve intention or tendency to create disorder, or disturbance of law and order, or incitement to violence. The court further held that the law should not be used to stifle the freedom of speech and expression or to suppress legitimate dissent. The court also emphasized that criticism of the government or its policies is not seditious unless it incites violence or has the tendency to create public disorder. The Kedarnath Singh case remains an important landmark in the history of the sedition law in India and has been cited in many subsequent cases to protect the freedom of expression and prevent misuse of the law. 6. Preventive detention. The Supreme Court has stated that preventive detention should only be used in exceptional circumstances as it is an exceptional power that affects individual liberty and must be used sparingly. The court has made a distinction between law and order situations and public disorder, where preventive detention may apply only in the latter situation. Preventive detention is the confinement of an individual based on the reasonable apprehension of them committing a dangerous activity to public order and security without undergoing a trial. The Constitution provides protection against arrest and detention, but these protections are not available to a person detained under preventive detention laws. Multiple laws, including the Criminal Procedure Code and the NDPS Act, permit preventive detention. Section 151 of the CRPC empowers police to make preventive arrests to prevent the commission of any cognizable offense. Constitutional safeguards against preventive detention. The Indian Constitution provides certain safeguards against preventive detention, which are as follows. 1. Article 22(1). This article provides that no person who is arrested shall be detained in custody without being informed of the grounds of arrest. 2. Article 22(2). This article provides that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest. 3. Article 22(3). This article provides that if a person is arrested or detained under any law providing for preventive detention, then the protection provided under Article 22(1) and 22(2) shall not be available to such person. 3. However, the detained person must be informed of the grounds of detention and given the opportunity to make a representation against such detention. 4. Judicial review. The Constitution provides for judicial review of preventive detention orders. 4. Any person who is detained under preventive detention laws can challenge the order of detention before a High Court or the Supreme Court. 5. Period of detention. The Constitution provides that a person cannot be detained for more than 3 months without obtaining the opinion of an advisory board. 5. The board must consist of persons who are qualified to be appointed as High Court judges. 6. Right to counsel. The Constitution provides that every person who is arrested and detained shall have the right to consult and be defended by a legal practitioner of their choice. 7. Right to information. The Constitution provides that every person who is arrested and detained shall have the right to be informed of the grounds of their arrest and detention. 7. Unlawful Activities Prevention, ACT. The Unlawful Activities Prevention Act, UAPA, was enacted in 1967 to prevent certain unlawful activities of individuals and associations and deal with terrorist activities. The Act defines unlawful activity as any action that questions the sovereignty of India, disrupts the integrity of India, or leads to the cession of a part of Indian territory. Cases under UAPA are investigated by both state police and the National Investigation Agency, NIA. The Act gives the central government the power to impose all India bans on associations, and there are provisions for a tribunal to review or hear an appeal against the ban. The Act can hold both Indian and foreign nationals accountable in the same manner if the crime is committed on foreign land outside India. The Act has been amended several times, with the most recent amendment in 2019 to enhance its scope. In India, there are several laws that provide for preventive detention, which is the detention of a person without trial or conviction, in order to prevent them from committing a future crime or maintaining public order. Law providing for preventive detention in India. The most prominent law that provides for preventive detention in India is the Maintenance of Internal Security Act, (MISA) of 1971. MISA allows for the preventive detention of individuals who are deemed a threat to the national security or public order. The law was initially enacted during the emergency period, 1975 to 1977, but was later repealed in 1978. However, other laws in India also allow for preventive detention. These include the National Security Act, (NSA) of 1980, the Armed Forces, Special Powers Act, (AFSPA) of 1958, and the Unlawful Activities Prevention Act, (UAPA) of 1967. The NSA allows for the detention of individuals who pose a threat to national security or public order, while the AFSPA allows for the detention of individuals in certain areas declared as disturbed by the government. The UAPA allows for the detention of individuals who are suspected of being involved in terrorist activities or unlawful organizations. It is important to note that preventive detention is a controversial issue in India, and there have been concerns raised about its potential misuse by the authorities. The Indian Constitution provides some safeguards against arbitrary detention, such as the right to legal representation and periodic review of the detention by an advisory board. However, critics argue that these safeguards are not always effective in preventing abuse of preventive detention. 8. Phone tapping. Phone tapping refers to the secret monitoring of phone calls and internet-based communications by a third party. In India, both the central and state governments have the authority to tap phones. At the central level, 10 agencies, including the Intelligence Bureau, (CBI), and Enforcement Directorate, are authorized to do so, while in states, police have the power to tap phones. Orders for phone tapping can be issued only by the Secretary, Union Ministry of Home Affairs, or their state counterpart in writing, although in exceptional cases, lower authorities may issue the order. The order must be communicated to the competent authority within a specified time period. Any tapping by agencies other than those authorized is illegal. Constitutional and legal safeguard on phone tapping in India. The Indian Constitution provides several fundamental rights to its citizens, including the right to privacy under Article 21. However, this right is not absolute and can be restricted in certain circumstances, such as for the prevention of crime or in the interest of national security. Phone tapping, also known as wiretapping, is a form of surveillance that involves monitoring or recording telephone conversations. In India, phone tapping is regulated by the Indian Telegraph Act of 1885 and the Information Technology, Intermediary Guidelines and Digital Media Ethics Code, Rules, 2021. The Indian Telegraph Act of 1885 allows for interception of telegraph messages in certain circumstances, but does not explicitly mention telephone conversations. However, the Act has been interpreted by courts to apply to telephone conversations as well. The Information Technology, Intermediary Guidelines and Digital Media Ethics Code, Rules, 2021, regulate the functioning of intermediaries, including Internet service providers, social media platforms, and messaging apps. The rules require intermediaries to comply with government orders for interception or monitoring of any information generated, transmitted, received, or stored in any computer resource. In addition to these laws, there are several legal safeguards in place to prevent the misuse of phone tapping. For example, phone tapping can only be authorized by certain high-ranking government officials, such as the Home Secretary or the Cabinet Secretary, and only for specific purposes such as national security or prevention of crime. Furthermore, the Indian Telegraph Rules, 1951, provide for the recording of all phone conversations that are intercepted, and these recordings can only be used as evidence in court with proper authorization. Overall, while phone tapping is allowed in certain circumstances in India, there are legal and constitutional safeguards in place to ensure that it is not used arbitrarily or for unlawful purposes. 9. Right to be forgotten. Recently, SC directed its registry to remove details of a couple from search engines and internet. Right to be forgotten, RTBF, is the right to have publicly available personal information removed from the internet, search engines, databases, websites, or any other public platforms, once the personal information in question is no longer necessary. The origin of RTBF can be traced back to the right to oblivion in French jurisprudence. RTBF is not an absolute right and has been recognized as a statutory right in the European Union under the General Data Protection Regulation, GDPR. Article 17 of GDPR provides right to erasure, or RTBF, which permits a data subject to request a controller to delete personal data concerning him or her without undue delay. In India, there is no law that specifically provides for RTBF. The right to privacy includes information that is not public, whereas the right to be forgotten involves removing information that was publicly known at a certain time and not allowing third parties to access the information anymore. Thanks for watching. Please like, share and subscribe for more content like this.